A determination of allegations that there were irregularities would require evidence. Similarly, the contention of the petitioners that there was a breach of Order 60 would require evidence. The petitioners in this case have not produced any evidence to support any substantial breach of or non-compliance with the election laws, such as to affect the results. And as clearly stated through counsel, this petition was not relying on evidence in this regard. The petition, they said, is about a legal issue, whether Section 22 and Order 60 are constitutional or not.
With Monday's dismissal of the APNU-AFC's elections petition 8820P, this means that both petitions filed by the coalition have been dismissed by the High Court, although petition 9920P has been appealed. In her ruling, Justice George said that the March 2, 2020 election was conducted lawfully and there were no breaches, violations, or non-compliance with the laws of Guyana by the Guyana Elections Commission, GECOM. As a consequence of her decision, both Section 22 of the Election Laws Amendment Act and Order No. 60 of 2020 have been found to have been executed under the proper authority. Petitioners Claudette Tourne and Heston Boswick had contended that Section 22 of the Election Laws Amendment Act is unconstitutional and that Order No. 60 of 2020 is invalid, null, void, and of no effect. The Chief Justice, however, ruled that Order No. 60 of 2020 was lawfully created by virtue of Article 162(1)(b) of the Constitution and Section 22 of the Elections Laws Amendment Act to resolve irregularities, discrepancies, and anomalies occurring in the elections process and to determine a final credible count.
Hold that in order to exercise general direction, supervision, and have administrative conduct of elections, GECOM had to ensure the lawful and proper implementation of the RPA in Section 22. This was done lawfully by GECOM via Order 60, enabling it to issue instructions and take action as appeared necessary and expedient to resolve the controversies as part of its responsibilities to complete the elections process by delivering the results. There was no breach or violation or non-compliance by GECOM with the Constitution or the law governing elections, such as to make the election a sham or a travesty, as claimed by the petitioners.
The Chief Justice also laid to rest the petitioners' contention that the statements of recount could not replace the initial declaration made by the 10 returning officers, declaring that it can and did in fact do so. Justice George said there were undeniable difficulties in the election and said GECOM had to act to resolve those difficulties. In her ruling, she also mandated that the statements of polls and statements of recount, which are currently in the custody of the High Court for safekeeping, remains there until all appeals are heard and determined. The APNU-AFC filed its first elections petition in August 31, 2020, officially challenging the outcome of the March 2, 2020 elections and the recount exercise from which the People's Progressive Party Civic emerged victorious. A second petition, 9920P, was filed subsequently on September 15, 2020, also challenging the March 2, 2020 election. This petition has since been dismissed because former President David Granger was not served within the required 5-day timeline, and he has been found to be a necessary party in the proceedings. An appeal is pending. The petitioners wanted the court to declare that the elections were so badly held that the results from it cannot be deemed to be the will of the people. At the same time, they want the court to have David Granger declared as president under those very elections they claim were conducted against the electoral laws and constitution of the country. The petitioners contend that the chief elections officer was not required to use the data from the national vote recount to produce his elections report and from which the elections were declared. None of those reliefs were granted via the ruling on Monday. Opposition leader Joseph Harman said the appeal must and will be appealed.